Thank you, Mr. Shima. I will now call 125-925 State of Kansas versus Adam Drew Humphrey.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Adam Humphrey. I request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Your Honor, I would remind the court, this is a case out of Saline County. Mr. Humphrey pleaded no contest to battery of a law enforcement officer involving great bodily harm to a Salina police officer. Mr. Humphrey received a little over 20 years in prison for that. But the issue before us today is he was also assessed a little over $40,000 in restitution. Again, the question isn't whether Mr. Humphrey is responsible for some amount of restitution. There's bodily injury in this case. So the issue isn't whether Mr. Humphrey is required to pay some restitution. The question is how much in this case. That's the issue that this court granted review on. We claim that in our appeal to the Court of Appeals that the documentary evidence that the state submitted to support the restitution claim in this situation was not substantial and competent evidence to support an award of $40,000 in medical expenses when, for example, some of what was listed in that was legal expenses, and several of the things in that document were things that we don't know what they are. We don't know what they are today. And so our claim was that that's not substantial and competent evidence. The Court of Appeals said I was making an evidentiary claim, somehow maybe that document wasn't admissible, and because we hadn't objected to it below, that we had waived that under 6404. And again, I appreciate the Court of Appeals' help in helping me frame my issue, but that was not the issue that I raised. The issue that I raised was whether or not there was substantial and competent evidence, whether that document constitutes substantial and competent evidence to support the restitution award.
Beyond Rule 6404, which seemed to be the rationale of the panel, do you also believe that the preservation rule, our sort of common law prudential rule, doesn't apply either to a substantial competent evidence challenge because it's akin to a sufficiency of the evidence holding the state to its burden of proof? Is that your argument?
That's right, Your Honor. And in fact, I mean, we can look at in contrast. So my colleague cited like State v. Shank for the proposition that if you fail to object to the workability of a restitution plan, that then you can't bring it up on appeal. In fact, by the way, I mean, that's part of why I didn't raise anything about workability in this appeal, because this court has said if you do make that objection, you, the defendant, have the burden to show it's unworkable. You have to put on evidence, I assume substantial competent evidence, that it's unworkable. And there's no evidence of that in this case. That's why I didn't raise any issue about workability. But I do believe, and I believe this court's precedents in Smith, for example, stand for the proposition that the state does have the burden to show substantial competent evidence to support its restitution award. And so, yes, now my colleague has accused me, or maybe that's too strong a word, but has asserted that I'm conflating sufficiency and substantial competent evidence review. And that's a fair assertion in that, yeah, I agree that substantial competent evidence is like or is akin to sufficiency. It is the job of an appellate court reviewing the record and looking at all the evidence in a light most favorable to the party that prevailed below to see whether or not there is some evidence, substantial competent evidence to support that award. And so, yes, Your Honor, we are, again, it's hard because restitution isn't a civil judgment. This court has said restitution is not punishment. So perhaps it's some sort of sui generis award. It's not entirely clear. But certainly this court in Smith said that every restitution judgment must be supported by substantial competent evidence.
And then on the merits, let me just, if you don't mind talking a little bit about that, your briefing or your petition suggested the only evidence was the exhibit that, or the attachment to the PSI, the chart that you've explained. But in our Taylor decision, we sort of clarified that the responses elicited by a trial court judge at sentencing is also considered evidence, albeit it's unsworn. So maybe it doesn't have the same weight, but it's evidence. So we have the exhibit, but then we have maybe a couple of responses in the record from the prosecutor, sort of confirming that, yes, these are essentially, I think is the quote, medical expenses.
Responses from the defense attorney, Your Honor?
From the prosecutor.
Okay.
Yeah, I'm less concerned about the defendant's response because it was essentially, as I read the record, saying, I don't have a stake in the game. I don't disagree that they're medical, but the proof that they were medical, I mean, there are a couple other statements from the prosecutor that says these are essentially medical expenses. Is that enough to get it over the substantial competent evidence hurdle?
Obviously, we argue that it's not, Your Honor, in that, and
why?
particularly, when you look at Smith, I mean, in Smith, the party said, we think the damages are 4,100 in this case, but the court said, look, you still have to look at all the evidence and say, does the evidence support that assertion, even by an attorney in that case? And so when you look at that, at the documentary, this case, the only documentary evidence of what this was, and you look at, and you can say, were all of those medical expenses? One of them was listed as legal expenses. And so this court can say there seems to be a problem with the proof in this case. That's our argument that the Court of Appeals would not hear.
Maybe one last question then. Is there any argument from the record that you could construe the district court judge's ruling to be an award of damages as reflected in the exhibit, and the judge just used medical expenses as shorthand as a descriptor for all those categories of expenses? And even if you could construe her ruling that way, would it even matter if we don't know what those categories are?
It would be, okay, I'm trying to break down your question, Your Honor.
Sorry. 2 parts. I guess my first part of my question
Your
is.
last question. Go ahead, Your Honor.
I was just going to say, the first part of my question was simply, did the district court judge rule that she was awarding restitution limited to medical expenses? Or was it a broader ruling that, no, I'm just awarding restitution as reflected in this document?
Yeah. Your Honor, so the answer to your question is I don't remember standing here, like how detailed the district court's ruling was.
Okay.
But the answer to your second question then is it wouldn't matter, because the point is whatever those things are, they have to be there has to be proximate cause and direct and sufficient but for cause that my client caused them, and it's not something else. And whatever the ruling was, the document in this case we argue is not substantial and competent evidence that it was my client's responsibility. Your Honor, again, but the remedy in this case, if you agree with that, I mean, you could remand this to the Court of Appeals because they've never heard this. So this had, the merits of this have never been decided by an appellate court. So that's one possibility. You could reach the merits, and if you do reach the merits, under Smith, you said in a situation very similar to this, you could remand it for further hearing on what these other things are in this document. That could be an appropriate remedy, or you could just simply say that the state failed to prove these things and reduce it to what was medical expenses, that there is a clear link in that of a little over $17,000. So we would ask for that in your case, Your Honor. Thank you.
Good morning, Your Honors. May it please the court. Assistant Solicitor General Ryan Ott, appearing on behalf of the state of Kansas. Generally, our courts, when we deal with restitution, our courts require that any argument of restitution on appeal be preserved. As my colleague noted, I cited Schenck in my brief, but also this court's opinions in King and Hunziger required. King had to do with workability, Hunziger with an argument that the restitution wasn't fair market value. Both required preservation. Arnett required preservation, although it decided to go ahead and hear the merits, but it did note preservation was required. And I would note that even the defendant in Smith recognized that he had to raise preservation because his substantial competent evidence argument wasn't objected to below.
But isn't it a different animal, the substantial competent evidence? I mean, it's really, to me, it is almost akin to a sufficiency challenge. It's just, in this case, it's the judge that's the fact finder, not the jury. And you're testing whether that record held the state, in this instance, to its burden of proof.
I just want to make sure I understand your argument or your question correctly. You're asking me if it's substantial competent evidence is different than the other cases that I mentioned.
Correct, yes. And why it may not be the type of argument, just like sufficiency of the evidence challenges, that wouldn't really fall under our preservation rule umbrella.
I agree that it is different than workability, and it's different than whether you're liable for the entire amount. But while substantial competent evidence might be similar to sufficiency evidence, I do think there's a difference there. And that sufficiency evidence, it really goes to whether, I mean, we see it most in criminal convictions, whether a conviction was supported by evidence. My colleagues, the cases he cited to all were for convictions, whether conviction was supported or not, restitution. Whereas substantial competent evidence, it asks whether the facts support a certain legal conclusion. Here, what's issue is whether this restitution was for medical expenses. The court determined, based on the evidence provided, that it was for medical expenses. And so the question is, does the evidence support that legal conclusion? And whether does the evidence support whether Humphrey's injury was excuse me, whether Humphrey's injury caused Officer Way's injury and the medical expenses. And here, the failure to object didn't provide the district court with that opportunity to make those necessary factual findings that could have supported that legal conclusion, that could have allowed this court to make frankly, a full determination based on the evidence.
But the court made the factual finding, right, that the $40,000 some odd was medical expense.
Yes, the court did determine that. And that's something that Mr. Humphrey and his attorney both agreed to. Or I should say, rather, his attorney said that he didn't disagree when the court asked Mr. Humphrey directly if he disputed that. He said no as well. And based off of that, as well as the state stating that the document constituted a breakdown of what was essentially medical expenses, the court made that determination.
And so it almost sounds like the argument is that the failure to object sort of didn't give the state or the judge the opportunity or especially the state, to develop the record to support a district court finding that those were medical. But that's sort of, in Smith, we sort of rejected that line of thinking under the invited error doctrine.
I disagree with your interpretation of Smith. At the Supreme Court level, Smith was about the invited error doctrine.
Right.
And as you said, and rejected, saying that acquiescence is not invited error. And we don't argue that invited error occurred here. And then Smith went on to found there wasn't substantial competent evidence. But there is a difference between Smith in this case on that level. And the difference is that in Smith, the evidence was at trial that Smith stole approximately $3,000. And then at the sentencing hearing for restitution, they asked for $4,000. And his attorney said, I agree with that. The evidence was at trial. So it's very clear that there was no evidence to support a $4,000 restitution, which is why this court remanded to give the state an opportunity to actually hold an evidentiary hearing. Here we do have an additional evidence in this document that's included in the PSI, which provides different evidence. But then I would just also state that there's a difference in that. I'm sorry, I lost my train of thought. Smith did not address preservation at all. In the Court of Appeals, Smith acknowledged he didn't object. He then argued an illegal sentence, and then also raised the preservation exceptions. The Court of Appeals said, even if we assume this is preserved, there's invited errors. So the Court of Appeals did not address it, ruled on invited error, and this court on the petition for review just addressed the invited error issue, not preservation.
So under your position, if in the next case, if we adopt your position in the next case, if the table that we see here only included legal expenses, it was $100,000 in legal expenses, and there was no objection lodged, then we couldn't hear that.
Not necessarily, Your Honor. If there was no objection lodged, it's not preserved, and then it is the appellant's burden to raise the preservation requirement or the exceptions to the preservation requirement and to argue whether one of those applies. This court, as the Court of Appeals noted, appellate courts have the discretion to decide whether to hear unpreserved claims. So it would be unpreserved. The defendant could argue.
So it's your
Preservation.
position that we have discretion to hear it.
Yes, it's my position that you have discretion to hear it. The Court of Appeals determined that it was not going to hear it due to the lack of an objection and the lack of any argument as to the preservation exceptions.
Okay, and if we do go to the substance, would you concede that legal expenses are not medical expenses?
Are you talking about specifically this case or are you
This case,
hypothetical?
this case.
Not
Oh,
necessarily.
I could say, okay, every case, I don't know.
Not necessarily, Your Honor. I admit there's not a lot of detail here. There's not a lot of description, which would have been very helpful.
There's a pretty big description, legal.
But this is, as the state noted when it submitted this document, this is a breakdown of medical costs. And well, I would submit that this is, this resulted from a crime. Officer Way was shot in the line of duty, and the city the city paid for his medical expenses.
What does that have to do with his legal bills?
It doesn't say that it's for legal bills.
It says legal.
It does say legal, Your Honor. I'm not ignoring that. It could be for his legal bills, but frankly, it could also be the legal department had to fill out documents for workers' compensation. That could go to the medical expenses too. We don't know, which is why if this court finds it's not substantial competent evidence, I've asked you to remand to the district court for a full evidentiary hearing because it's not a super detailed document. I acknowledge that, but I still would argue that there's substantial competent evidence that a reasonable person could look at this, look at the state's explanation that it is a breakdown of the medical expenses. The breakdown suggests that there would be multiple categories within the medical umbrella, as well as Mr. Humphrey and his attorney's acknowledgement, or at least agreement that they agree that it's medical expenses, and find that supports that the substantial competent evidence that this is medical expenses.
What if, what if it didn't have the table? What if it just said medical expenses and had a number?
I would argue that it says medical expenses, and that would be sufficient evidence, especially considering their acquiescence.
What do you have to prove to show restitution? What does the state have to prove?
We have to prove proximate cause. We have to show cause and fact and legal causation.
So if medical expenses, if he had medical expenses, well, we could change the plaintiff to a woman, and she had medical expenses associated with the pregnancy that was unrelated. I mean, she had the baby before this incident even occurred, but they were medical expenses. Is there sufficient evidence to show if it just says medical expenses?
No, you have to show that there is a relation between the crime and the restitution of medical expenses, but.
And where was that shown here?
Well, I would note that Humphrey does not dispute that his crime of conviction led to Officer Way's injuries. There's really no dispute that Officer Way is injured.
Where does it show that these medical expenses were associated with his injuries?
Because the document provided by the state is a breakdown of the medical expenses. That's how the state presented it, and that's how, I mean, his attorney and he agreed to that fact.
He didn't agree to it. He just acquiesced.
Okay, he didn't. I apologize. He did not disagree to it, Your Honor. But they had an opportunity there. His attorney did, object. He objected as to workability. Frankly, like I recall, he could have raised workability if he wanted to, because it was preserved, unlike this argument. But his attorney objected to workability. The district court specifically asked him, "Is that your only argument?" And he said, "Yes, that's all I have." And the district court asked him, "Well, do you disagree with this medical expense?" He said, "I don't disagree." When Mr. Humphrey interjected, he asked, "Do you dispute this?" And Mr. Humphrey said, "No." Yeah, as you said, Your Honor, I fully acknowledge that this is not very detailed. I would love if it didn't just say medical, legal, and it had a huge definition. But it doesn't. This is the evidence we have in the case. And I would argue under the substantial competent evidence standard and proximate cause, it's satisfied here. If there are no further questions, I just ask this court to affirm the Court of Appeals that this issue was not preserved. And if this court were to decide it reaches the substantial competent evidence, then I would ask that it remand to the district court for a full evidentiary hearing. Thank you.
Thank you.
Your Honor, I don't have anything else in response to my colleague's argument.
Any questions?
Thank you, Your Honor.
Thank you. Thank you to both counsel. Court will take this matter under advisement. Thank you.